So I was reading this piece from Joe Banzant, who is a law professor with George Washington University Law School. He's not a Trump fan at all. He does not like Donald Trump. But even this law professor is saying this judge's ruling against Donald Trump, this temporary restraining order against Donald Trump is wrong, and it's got to be overturned. Okay? Let me read to you what he says about this. And it's a little bit of legalese, so I'll try to simplify it here. He says, number one, it's very doubtful that a state, in this case Washington State, even has what's called standing to raise legal and other constitutional claims on behalf of its own citizens, let alone on behalf of non-citizens in other countries seeking to enter the United States. In other words, Washington State, how can a judge in Washington State propose to speak on behalf of people in other countries wanting to come into the United States? He doesn't have standing. This law professor goes on, arguing that Donald Trump's executive order, as Trump wrote it, is, quote, separating, or as the judge wrote it, here's what the judge claims about Trump's executive order, quote, it's separating Washington families, harming thousands of Washington residents, damaging Washington's economy, hurting Washington-based companies, and undermining Washington's sovereign interest in remaining a welcoming place for immigrants and refugees, end quote. Well, this sounds quite conjectural and contrary to established precedent for establishing legal standing. Number two, he says, a long line of cases under what's called the plenary power doctrine makes it plain that many constitutional protections do not apply to foreign citizens outside of our borders. Even a complete and total ban on admitting any and all Muslims technically would be constitutional because they don't enjoy the protection of the Equal Protection Clause, which prohibits discrimination on the basis of religion. Number three, the United States has banned or at least delayed the entry of foreigners on the basis of nationality many times, including decisions by former presidents like Jimmy Carter and others. It would be hard to conclude that all of these prior actions were unconstitutional. And fourth, the President of the United States has clear statutory authority under 8 U.S.C. 1182F, which states, quote, whenever the President finds that entry of any aliens or any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem appropriate, end quote. And then to take it a step further, this law professor, who's an anti-Trump law professor, points out even the liberal 9th U.S. Circuit Court of Appeals that's reviewing this case right now, they have even upheld, as they did in 2012, quote, that statute specifically grants the president, whereas in the national interests do so, the extreme power to prevent the entry of any illegal alien or group of aliens into this country, as well as the lesser power to grant entry to such person or persons with any restriction on their entry as he may deem to be appropriate, end quote. I mean, that was actually the ruling in 2012 from the 9th U.S. Circuit Court of Appeals. Now, this is when Barack Obama was president. The language could not be more clear. Donald Trump, as president, has the authority, if he deems it's for national security purposes and the best interest of this country, he has the legal authority to say temporarily, you can't come into this country from these particular ISIS hotspots. But now you have liberal judges that said it was fine when Barack Obama did it, fine when Jimmy Carter did it, fine when Bill Clinton did it, but now it's not fine. That's the problem so many of us have with this ruling. All right, well, it's not done. We'll see what happens with it. All right, here's what I want to do right now.